Session on the protection of liberal democracy and the independence of the judiciary. We have a distinguished panel, Professor, by order of the speaking, Professor Pascal Pichonnaz, who is on my left side, from Switzerland, is President of the European Law Institute, and we have a President Marko Bošnjak, the President of the European Court of Human Rights is from Slovenia. We also have Professor Margaret Satterthwaite, who is from the United States, and she is the UN Special Rapporteur on the independence of justice. Hello, Margaret. Or you allowed me to call you Meg, so I can call you even in public. Okay. She is the UN Special Rapporteur on the independence of judges and lawyers, and we shall hear her later. President Valentina avličić. She is the President of the Supreme Court of Montenegro. And Vice President Doris König from Germany. She is Vice President of the Federal Constitutional Court of Germany. And last but not least is our colleague, Professor Elise Muir. She is the head from Belgium. She's the head of the Department for International and European Law in Leuven University. I don't know why in Belgium the Catholic University is with K, but Flemish. Okay, I should have known it because I'm a member of the Royal Academy, Flemish Academy of Science, of Arts and Science. So I will reprimand myself for not knowing it. So I would like to begin just with notes of thanks to the President Javier Remades, to the Mayor of the City of San Diego, to the Executive Director, Mr. Thomas, and to the also Deputy, Mrs. Irene Esteban, and also to Yaki Rodriguez and to our friend Diego Solana, who is in charge of programs and who approved also this session. So we have to be grateful to him. And special thanks are also due to the European Law Institute, who helped coordinate this session, and to the President, Professor Pichonnaz. The ELI has initiated 2 reports which are very relevant to our session. One report is the Charter on Fundamental Constitutional Principles for the European Democracy. This was published in 2023. And the other one is the ELI Mount Scopus, European Standards for Judicial Independence. So they are both important documents which I recommend you to look it up in the internet. Today everything is easily accessed. I would like to make just very, very brief remarks. The first one is to just say a few words about judicial independence. Judicial independence is a fundamental principle of liberal democracy and the rule of law. It guarantees that the judges are independent and impartial, and that their decisions is based solely on legal consideration and free from improper influence. And in the session I just took part, I think Doris was, and you were also, I said in my last sentence that the judiciary must protect democracy, otherwise democracy will not protect the judiciary. But I said it in not in negative, but in positive way, that the judiciary must protect democracy, so democracy can protect the judiciary. So these two concepts of judicial independence and liberal democracy are very, very important. We will hear President Valentina Pavlovicic about these issues of judicial independence. And as regards the issue of liberal democracy, before that, Professor Margaret Satterthwaite will give a very detailed report about the international landscape of this particular subject. As to liberal democracy, it is not merely a system of periodic elections. It is a constitutional order grounded in the rule of law, separation of powers, protection of fundamental rights, and institutional accountability. This is a reference to the ALI Charter of Fundamental and Constitutional Principles of the European Democracy, which Professor Elise Muir was one of the two reporters, co-reporter, and we shall hear her presentation in the course of our session. And I want to mention here a very important case which was delivered by the Constitutional Court of Romania, invalidating presidential elections in Romania. This is the landmark case ever done because of distortion of the election campaign by digital bots and all kinds of fake news, including foreign intervention that was proven to the court here. So I would like now to start with our keynote speaker, Professor Pascal Pichonnaz, who will speak on the liberal democracy and judicial independence in an AI environment. I just want to mention that Professor Pichonnaz is a professor at Freiburg University, and he has held many visiting professorships. And I would like to say that he plays a central role in shaping legal scholarship and advancing cross-border dialogue on legal harmonization and the rule of law principles in Europe. So I would like to ask our keynote speaker to take the floor.
Thank you very much, Mr. Chair, for this too kind introduction. And let me start by thanking also the organizers of this World Law Congress. I think it's really amazing, and I'm really honored and happy to be with you this morning. Three buzzwords today in my talk: protection of liberal democracy, judicial independence, and AI. As president of the European Law Institute, I wanted to examine the interaction between two pillars of our European societies and the AI environment. As mentioned, the ELI Charter of Fundamental Constitutional Principles of a European Democracy is a set of 36 principles and commentaries prepared by two co-reporters, Professor Takis Tridimas from King's College London, or former at King's College London, and Elise Muir, professor at KU Leuven in Belgium. This charter has been approved in February 24 by the European Law Institute, and the charter purports to identify and articulate the constitutional principles which form the foundation of a European liberal democratic state. This means adopting underlying premises and in particular that such a state is based on majority rule, but is constrained at the same time by the obligation to respect the rule of law, including fundamental human rights. By liberal democratic state, this charter posits that at its heart, the ultimate source of political power is the people. To achieve that, it requires an institutional framework first to ensure for political power to be with the people, and a legal framework which provides for protection of fundamental rights, enabling individuals to develop themselves, protect them against violations by the state, but also favoring positive actions by the state to protect minorities and develop the fundamental requirements to live in this society. Third, artificial intelligence plays a growing role, as we've just heard, in our liberal democracies. Those must therefore provide for structural and legal framework, ensuring that the core values and fundamental rights of liberal democracies are reinforced and not torn apart by the use of AI and large language models. This means first that election and voting processes, which are at the core of liberal democracies, are not impaired or are unduly influenced using artificial intelligence to blur the reality of exchange of ideas, especially on social media, as has been just mentioned. But I wanted just to underline one aspect, the tunneling effect due to algorithms. Providing users with content they will certainly like triggers the danger of diminishing the ability of these individuals to be confronted with different ideas, to weigh and analyze them in a rational way, to determine whether they approve or dislike them. The creation of those communities fed with similar ideas they already share reinforces their views, but also creates a belief that this is the one view shared by all which really counts. Among other aspects, the ELI Charter provides for a Principle 6 on protection against disinformation, with a subsection 2 providing that, and I quote, all entities that provide access to public space, such as media undertakings, social networks, and online platforms, have a social responsibility to counter disinformation whilst respecting fundamental rights, including freedom of expression. This means including measures regulating political advertising, content moderation, and potentially removal of content. A second aspect is linked to automated decision-making. And Principle 32 of the ELI Charter and its 4 subsections address this in general terms by ensuring that fundamental principles of transparency, of accountability, of human review are respected by fixing categories of decisions according to the risk of infringing fundamental rights, and more specifically, sub-principles such as ensuring that the addressee are informed when AI is used and that the decisions are reasoned, as the principles mention. Now this leads me to the next point. Automated decision-making processes, and more specifically large language models, LLMs, allow to provide users with a text presenting a reasoning for any decision. Now, the text is based on the most probable sequence of words depending on the data set used to run the algorithm and the inputs prompt given to the algorithm. There is no reasoning, nor a copy of reasoning. The most probable sequence of words may look like a proper reasoning, of course, especially where the data set encompasses a multitude of reasoned decisions in one specific legal system. However, judges know that the most probable outcome is not necessarily the most accurate or most equitable answer in a particular fact setting or when inputs are slightly different. This is why human review is considered as central to the proper administration of justice and to protect fundamental rights, including the right to have a reasoned decision. It is therefore central that the judges review the reasoning of a decision to ensure that this appearance of reasoned decision is sufficiently close to what a reasoned decision would substantively be. I think that our systems of justice could accommodate automated decision systems, but for only some type of decisions first, and that's mentioned in this charter, but also that there is a kind of fundamental right to a decision by a human being at some stage in the process. Now, of course, I have no time to elaborate on that, what that would mean. But this leads me to my final question. Does the AI environment trigger a further risk for the independence of the judiciary? The Eli Mans Corpus European Standards of Judicial Independence, which were adopted by the European Law Institute in November 24, are the result of the work of 4 co-reporters, including our chair, Professor Shimon Shetreet, and a broad group of advisors, assessors, as usual. The output entails 38 standards provided with comments. Now, based on the premises that an independent judiciary is vital to maintaining the rule of law, democracy, and human rights, and therefore that judicial independence is part of fundamental principles of a liberal democracy, these standards seek to encompass specificities and traditions of states in Europe, while dealing with all areas of judicial independence, including judicial governance, promotion and appointments, and judicial discipline, but also ethical standards, which are also very important. Now, standard 23 of these principles use the word of technology, which includes artificial intelligence, and is divided into 5 subsections, and it provides for at least 9 different aspects of judicial independence in the use of technology. As acknowledged by the co-reporters, the use of data and algorithms in justice systems, and I quote, can carry substantial risks for judicial independence, impartiality, and the right to fair trial. These includes risk of biases, disclosure of sensitive data, false, inaccurate, or irrelevant information, over-reliance of technology, and disinformation, censorship, or control, end of quote. This is why that there is not only a duty of transparency when using AI or of reasoned decision, but as underlined by the comment of Standard 23, judiciaries have a duty generally to bring their judicial expertise into the use of AI and identify risks to the rule of law and right to a fair trial. To ensure judicial independence, therefore, one needs to guarantee the foundations of the rule of law and liberal democracy, and that means that judiciaries must have effective control as well as oversight not only on the output of any algorithm, but also on the design, development, and implementation of technology to maintain the integrity of the judicial decision-making process. To keep such oversight, judges need to understand the functioning of AI and to be trained on how to use AI. But they should also participate in the design, development, and of this technology. Now, I just give an example and I will conclude. The UK judiciary has recently been provided with an updated guidance for judicial office holders on AI. So a 10-page document that is not too long for judges to read. Not that they would not read long pages, but I mean, it's limited. And it gives judges the opportunity to better understand what they are doing when they are using the AI tool, which was put at their disposal only recently. So now all judges in the UK have an AI algorithm at their disposal, and they have also, of course, the explanations how to use it. So judicial independence in an AI environment starts with understanding what it means using such AI, but really imposes also on judges to participate in its design, implementation, development, while ensuring that human review of decisions generated by large language models are secured. There is, I'm sure, undoubtedly still a long way to go into that respect. Thank you very much.
Thank you very much, Professor Pichonnaz, for your analysis. Certainly, the AI cuts across all walks of life and all areas of activity, whether it is political campaigns like in Romania, or whether it is privacy issues of putting the head of a person on a naked body and shaming him or her. So we have to pay great attention, as you said, and I think the judiciary in England are good to issue a 10-page, maybe even 30-page, because to cover all these issues would require more text. And it is now my pleasure to present to you President Marko Bošnjak, the President of the European Court of Human Rights. He will speak on the role of international and domestic courts, like the international is in brackets, so international and national domestic courts in protecting against democratic backsliding. And of course, we all recognize the central importance of this very important institution, the European Court of Human Rights, in protecting human rights and developing doctrines to defend the rule of law, even if they are not written expressly in the convention. And I think the heritage you created together with your colleague, the heritage is helping courts around the world, national and international. And I would like to just mention that Professor Bošnjak, before joining the court in 2016, he held academic appointments at the University of Ljubljana and the European Law Faculty in Nova Gorica, while also advising the Constitutional Court of Slovenia and the Ministry of Justice. Justice President Bošnjak served as Vice President and Section President before he was elected as President. His leadership is marked by a deep commitment to upholding democratic principles and judicial independence in an era of increasing challenges to the rule of law across Europe. Professor President Bošnjak, please, you have the floor.
Thank you very much, dear Chair, Professor Shetreet, for this kind introduction. It obliges me indeed in my presentation, distinguished colleagues, panelists, distinguished all present here. As announced, I come from the European Court of Human Rights, so naturally human rights are at the heart of our mission, but this mission is closely connected to the protection of the rule of law and democracy. As I said already yesterday in my General Assembly address, this is a mutually reinforcing triangle, and I believe that this comparison is very fitting. Now, the rule of law is one of the central elements of the rule of law is independence of judiciary, which is particularly threatened by a phenomenon which now is very commonly labeled as democratic backsliding. What is central to this phenomenon is that it's not started by forces that would have no democratic legitimacy, right to the contrary. It started by usually executive and or legislative branch of government, which has full legitimacy obtained through fair and free elections. It takes issue with many elements of independence in the society, be it with free and professional civil service, with free press, with academic circles, but most of all, I suppose, with independent judiciary, by seeking to cut its competences in the sense that judges should not impinge upon the other two branches of government which have direct democratic legitimacy, that then they seek to appoint judges which would be more in conformity with this general will of people, and to, of course, discipline those who are not. They start all sorts of reforms, of measures which they label as reforms, the so-called judicial reforms, which are done under the pretext of judges being detached from the will of people, being prone to corruption, because they are not sufficiently competent, because they are not sufficiently efficient, and the like. I will take one example of such democratic backsliding, but there are many, not just, or at least some, within the legal space of the Council of Europe, and even more outside of it. But one prime example is the Polish so-called judicial reform, which has had many faces, or which had luckily many faces, starting by irregularities in the appointment of the judges of the Constitutional Court. Those interested in what happened there can read our judgment in the case of Xeroflor and others versus Poland. Then it continued by restructuring the National Council of Judiciary, which had a central role in appointment of judges, by simply terminating the term of previous members and appointing new ones, while prohibiting those from the previous composition to have any judicial review of that termination. You can read more about it in our judgment of the Grand Chamber Grzenda versus Poland. Then they introduced a lower retirement age, especially for the judges of the Supreme Court, but also for other judges of the general courts. Thereby, if you lower the age of retirement, you simply get rid of experienced judges who possibly are not in accordance with your likings, in particular in the apex courts, because they usually have a more advanced age than those in the lower levels of the jurisdiction. So you quickly start controlling the Supreme and the Constitutional Court thereby. Now here too, both, not just the European Court of Human Rights, but also the other European Court, namely the Court of Justice of the European Union, intervened. Our court, with a judgment in the case of Pajak and others, and the court in Luxembourg through two judgments in cases of Commission versus Poland. Then they set up in Poland specific chambers, doing with all sorts of review at the level of the Supreme Court. Once they started controlling the Supreme Court, they introduced the impossibility to challenge the judicial appointments of those who are unsuccessful in recruiting procedures. And last but not at all least, they introduced several disciplinary measures and other sanctions against those judges who were not acting in conformity with the will of the government. Now, how came that our court reacted in those processes at all? Normally, the design of judiciary is an internal constitutional issue. It's part of the national constitutional identity. And in that, international courts should not really interfere. Equally, the issues of retirement age and so forth, this is not normally an issue of human rights or the rule of law. Equally, when it comes to the issues of independence, this was very often seen as something which is not a legal interest or legal good which would be for the judges to seize it and benefit from it. It was for the parties to the judicial proceedings to benefit from it, but not for judges as such. Now, luckily, the Court of Human Rights in Strasbourg had certain precedents on which it could build its intervention. The case of Baca versus Hungary, involving the former president of the Supreme Court, who was sanctioned of Hungary, who was sanctioned for speaking out against the envisaged judicial reform, and one case which came from a jurisdiction which would not be considered as a problematic one, namely Astrason versus Iceland, but there was an irregularity in the appointment process of a judge, and our court, in that case, in the Grand Chamber, set a set of principles which we were then able to apply to the Polish cases, thereby avoiding a reproach saying, well, you are having one sort of standards for new democracies or for political forces which you dislike. You are liberals there, protecting liberal democracy, and because you don't like our political stance, you are interfering with us. No, this was not true. We simply applied the standards and further development that we had there. There was one other element, and it was very difficult to decide whether to put it in motion or not, in the protection of the judiciary, namely the interim measures. You may know that proceedings in Strasbourg take several years. And so, until our judgment, everything can, of course, fall apart in Poland in between, or in any other jurisdiction. But we had judges coming before the European Court of Human Rights, asking us for protection through interim measures, in order to prevent their disciplinary proceedings, their immunity being taken away in criminal proceedings, being transferred to another bench or to another court of a lower jurisdiction and the like. And usually we apply interim measures only in situations of life and death, so to say, or something where obviously we could never ever react any longer later. And one would say, well, independence of judiciary, if a judge is transferred, well, if he wins his case, he will simply be transferred back. Or if he is sanctioned, well, if he wins his case in Strasbourg, you will then, there will be some sort of reopening or whatnot. Well, the independence of judiciary is something which goes beyond the interest of an individual judge. But it strikes at the heart of the constitutional system of liberal democracy, if we are speaking of it today. So the court had to make a decision, and we decided, yes, we will intervene. We intervened with more than 30 interim measures indicated to the Polish government, and luckily they were respected, but in one case, but even in that case later on, and it's interesting to know that the Polish government said, well, a judge in a court in Poland does not want to follow your interim measure, and we cannot force him to follow it because we care so much about independence of judiciary. So they used the independence of judiciary against us. The government can do nothing because we care so much about it. Now, not to take too much of your time, what are the lessons to be learned from our intervention, which was not a sole one? We went hand in hand, we walked hand in hand with the Luxembourg court, and there too were very brave domestic Polish judges who acted in order to protect the independence of judiciary. They themselves faced sanctions, but then we protected them when they were facing sanctions in that. Namely, first of all, there is a central role of international justice to help protecting independence of the judiciary. That protection can be efficient. International courts have to speak with one voice in that. The democratic backsliding is not irreversible, luckily, as we can see. And now, I paid an official visit to Poland in December this year, to the when the new government is already in saddle. But we could see how difficult it is to dismantle the effects of the democratic backsliding. It's not so easy. It's much easier to deconstruct independence than to rebuild it. But still, it's worth it. So I will stop here, not to take more of your time. I've spoken perhaps even a little bit too long, but we'll be happy to engage in a dialogue with you. That's so important. It should be interactive. Thank you.
Thank you very much, President Bošnjak, for this comprehensive analysis. And let me say that we, in the project of ELI, Mount Scopus European Judicial Standards, relied very heavily on the jurisprudence of your court, as well as the European Court of Justice, and of course other international and domestic courts, and compared with what we had in the New Delhi Code of Minimum Standards of Judicial Independence, which we formulated together with the IBA, that was in 1982, we didn't have so many cases. But now, when we came to formulate this joint project with the ELI, we found a wealth of jurisprudence that helped us to be a little bit more active and more confident about defending judicial independence. And I commend you and your colleagues for the active role that you are playing in defending judicial independence. As I said, when you defend judicial independence and thereby you defend democracy, democracy will defend you, the judges. And now it's my pleasure to introduce Professor Satterthwaite, the UN Special Rapporteur on the independence of judges and lawyers, who will speak on undermining judicial independence, a typology of strategies used by autocratizing governments. Professor Margaret Satterthwaite is the United Nations Special Rapporteur, as I said, since 2022. She's a professor of clinical law at NYU School of Law, one of the finest institutions, where she directs the Robert L. Bernstein Institute for Human Rights, the Center for Human Rights and Global Justice, and the Legal Empowerment and Judicial Independence Clinic. She is a prolific author and editor and brings an interdisciplinary approach to understanding and defending the institutional frameworks essential to liberal democracy and the rule of law worldwide. Please.
Thank you so much, and thank you very much for the invitation to be here. It is a real honor, Mr. Chair. And I'd also like to just acknowledge that we have such an eminent, not only panel, but also individuals in this room. So, excellencies, colleagues, your honors, it's a real pleasure to be here. So I will not speak very long because we need to make sure that we have time for everyone. But what I would like to do is tell you a bit about a typology that I've created of attacks on judiciaries that I'm seeing in my work as the Special Rapporteur. So this comes out of looking really at places where you have this process of autocratization. And I like to use that terrible term because it recognizes that any state can become more autocratic. It doesn't really matter where you start on the spectrum. You can always, unfortunately, go in that direction, or you can come back toward liberal democracy, no matter where you started. So the four forms of attack that I have unfortunately seen in many parts of the world, and in fact I can say in every region, are really about attacks on judicial institutions. First, there are two of those kind, and then attacks on judicial personnel and judicial operators more broadly. So the first two categories that attack institutions, the first is one we're very familiar with, which is capture. And I think we just actually heard a lot about how capture can occur. I need to be closer. Yes, is that better? Okay. Okay, excellent. Yes, we exactly. Okay, excellent. So capture, of course, includes legal reforms that decrease judicial independence and increase political control or influence. And that really reduces the capacity of the judiciary to act as a check on the political powers, excuse me. And these reforms are often focused on increasing the influence of the executive or the legislature over judicial selection and appointment, with the hope of engineering the appointment of what might be seen as loyal judges who they hope will favor political actors. And another tactic that we just heard about is creating new judicial vacancies, either by expanding courts, removing existing judges, including by impeaching sitting judges, or purporting to alter their judicial term limits, or as we heard, lowering the age of compulsory retirement. So capture is very familiar to us. And I'd like to introduce also then curbing. And curbing is a way of using legal reform to reduce the power of independent judges and judiciaries. These kinds of curbing measures risk negating or dramatically reducing the capacity of judges to uphold the rule of law. And just a few examples. First, removing or restricting courts' jurisdiction to review particular laws or particular kinds of laws. Limiting judicial oversight in certain politically sensitive cases, often those that are purportedly involving national security or other categories like that. Authorizing political branches of government to override judicial decisions. Sometimes mandating weaker standards of review by the judiciary in some or all cases. And then we also see independent judges having their capacity to act as an effective check on government power curbed by simply reducing their resources. So making it very hard for judges to do their work, reducing the number of assistants they have, reducing the capacity to obtain new technology, for example. So in relation to both capture and curbing, some would argue that the values of democracy and self-determination mean elected governments can make reforms to their system. And that is very true. But in international standards on judicial independence, as we've already been talking about, and human rights standards require that we really ensure the protection of judicial independence. So these first two categories can be promoted by political leaders sometimes as neutral reforms. They're simply improvements to the system. And the last two categories really cannot be marketed as such. These I call instrumentalization and weaponization. So both of these categories involve the targeting of individual justice operators, including and especially independent judges, for their work to uphold the rule of law and hold government officials to account. So instrumentalization entails the misuse of existing legal institutions, procedures, or laws to exert undue political influence on judges and justice operators. For example, disciplinary proceedings may be abused, and sanctions, including suspension or removal, or simply sanctions on the functioning of a court, may be imposed on individual judges or entire courts in reprisal for upholding the rule of law. Judges have been removed from office for imposing convictions in political corruption cases or for challenging corruption in international courts. In many instances, removal occurs without due process. Conditions of service may also be instrumentalized to influence on judicial conduct. So judges may experience the withdrawal of their security protection, transferred to locations viewed as under-resourced, as dangerous, or otherwise undesirable. And most damagingly, judges and prosecutors who are perceived as threatening to state authorities become the subject of criminal prosecution. Criminal prosecutions have been used to target justice operators who handle cases involving grave human rights violations or corruption, and may be getting too close to centers of power. Criminalization demonstrates that judges who are assigned the role of upholding an independent legal system can become personally vulnerable to punishment for simply carrying out their professional duties. So the final category of threats to judicial independence is what I'm going to call weaponization. If instrumentalization masquerades as a lawful action, weaponization represents an extreme form of threat against independent justice operators involving facially improper and illegal acts. First, and this is a very, very popular one right now, public disparagement and denigration of individual judges by officials of the state. So you have often a very targeted campaign of individual judges against individual judges by the executive, who denigrates them with demeaning language, and often, unfortunately, gendered language as well. These are often followed by private acts of violence against judges. If you see the executive acts and language as sort of creating the field of permissibility to attack physically judges, we do see this. Sometimes judges are arbitrarily detained or subjected to temporary disappearance. And most shockingly, it has happened that judges are killed and their families have been subjected to physical attack. The targeting of individual judges can serve as a punishment, a retribution, and a warning for other judges to not challenge the legality of government action and to make sure that those executives have space to act. Given the severity of the threats faced by judges, coupled with the essential role that they play in upholding democracy, we must take action when we see these patterns emerging. And so I will stop here, but what I'd like to say is that it's imperative that we all across these spaces can act in solidarity with judges when they're under attack, and that we identify the patterns across these different nationalities and advance a sense of solidarity and protection for judges who are playing their role in upholding the rule of law. Thank you.
Thank you very much for your presentation and your active reports that contribute to the promotion of judicial independence. I think also that this institution of UN Special Rapporteur that was established by the United Nations is helping lawyers and judges to keep and maintain their independence. And that's why it's very important to combine not only judges but also lawyers who are the officers of the court and who have to defend the citizens before the court against governments and against big corporations. And now it is my pleasure to present to you President Valentina Pavlicic, who is the President of the Supreme Court of Montenegro, and she will address us on the challenge of Montenegro, that Montenegro faces in EU alignment, judicial independence, and human rights in judge mandate termination. Well, the President serves as the head of the Supreme Court of Montenegro, following a distinguished career in the judicial offices and upholding justice and the rule of law. She began her career as a criminal judge in, if I pronounce it correctly, is Podgorica. Podgorica, and I practiced it, so that's why I was successful. and went on to preside over the criminal department of the High Court. Very important to say that beyond the courtroom, President Pavlicic has contributed her experience and expertise to leading international institutions. Her broad experience reflects a commitment to judicial independence, alignment with European legal standards, and the reinforcement of democratic values in transitional legal system, as President Bošnjak said, the new democracies, which is, this transitional period was very challenging to make sure that democracy will be stable and solid. Please, we are looking forward to hearing you.
Thank you, Professor. Thank you, Chair. Dear colleagues in the panel, dear colleagues in the audience room, I cannot start my address without expressing my professional and my personal pleasure to be part of this very, very important event for all of us in the justice system. Also, it's my pleasure to speak about the Montenegrin faces in European part, especially for the very, very two important pillars such as independency of the judges and protection of human rights of a national level. Looking at the recent historical context, I want to point out that since the restoration of independence of Montenegro 2006 has taken a series of reform steps towards the professionalization and standardization of judiciary through changes in the legislative framework, where the introduction of the body such as Judicial Council, a body that ensures and guarantees the independence, sovereignty, responsibility and professionalism of the courts and judges, opened an institutional framework for strengthening the autonomy and independence of the judicial branch of government. Namely, fully aware that issue of the independence of the judges is not a privilege, but an obligation and one of the fundamental constitutional determinants without which there is no, nor can be spoke of the rule of law. And that as every democratic state, we strive for a system established on the rule of law, because it is the antithesis of the arbitrary power. Faced by daily needs of a modern society, for a long period of time, Montenegro has been investing significant resources and time in the continuous education of judges in accordance with European and international standards, such as case law of European human rights, which include also on improving knowledge, ethics, and integrity and the necessary skills for managing judicial proceedings. The Constitution guarantees a wide range of rights. However, such as reflection needs to be applied in practice itself in order to minimize the gap between the norms and their full application in practice. A special emphasis is placed on the fight against impunity. The priority is efficient and impartial investigation and trial in cases of high-level corruption and organized crime. These are tests of maturity of an independent and efficient judicial system. As we all know, as judges also, we are obliged to hear the parties who have equality arms at their disposal and to conduct evidentiary proceedings in accordance with the procedural law, so that as a result of all this, a high quality and reasoned court judgment is delivered. Therefore, judge must act without fear, sympathy, or any arbitrariness in relation to any person, and particularly in relation to appointed person, because it is matter to trust that general public must have in the courts, and it is built precisely by knowledge and consistent observance of ethical principle in such cases. Public perception often does not reflect the complexity and the length of the proceeding the judges, and facing with they must not be influenced by public pressure. Thus, our role as the presidents of the courts is not only to manage to the institutions. Our responsibility is to preserve values such as independences, responsibility, and trust, because justice is not abstract idea. It takes shape every day in the courtrooms, in our decision, in our action. Acting in accordance with the vision of European modern and efficient judiciary, I am free to state that certain measures which were taken are already given results, so the public can be convinced that procedures are more efficient and that in the near future we can expect a large number of first instance as well as final court decision in all types of the cases. For us, in judicial branch of power, this is conditio sine qua non, so that we can respond to the challenges of large number of cases of all matters. Investigating in judiciary means investigating in the future, instability of the state and its economic and overall development. All we know, the independence of judges is not luxury. It is condition without which there is no fair trial. It must be imperative of all of us. Dear colleagues, how can we talk about the rule of law if justice arrives too late? It is time to see clearly that justice exists, that is shared, and that it's available. Therefore, presidents of the court must strive to contribute to the achievement of standards from their position, not only that justice is served, but also that is seen to be served in approximately reasonable time. This is what the judiciary can and should do, and today I can freely say that the tracing of such a direction was started with completely realistic view and awareness that it is an extremely difficult task. But all these reforms in the area of the fight against organized crime and high-level corruption cases and consistent application of the law represent a significant step towards more visible and better results in area of rule of law as imperative of Montenegro society. And I am determined and persistent in tracing such a path. The Supreme Court of Montenegro and thus Montenegrin judiciary as whole will be dedicated to achieving all goals and tasks guided by the example of creating a climate direct communication, which principle of work would be transferred to all lower courts. Despite the institutional mechanism, I often face with challenges that cannot be seen in statistics, personal attacks, attempts to discredit and doubts about every reform initiative. Yes, independence of justice, as I said, is an obligation. And last but not least, I want to finish with some sentence from Justice Ruth Bader Ginsburg, who said, "Whatever we choose to do in life, leave our marks." It means that we did not do for ourselves. And that's how we live in the world a little better than the one we lived. And so, dear colleagues, we should fight for the things we care about, but we should do it in such a way as motivate others to join us on that journey. Thank you.
Thank you very much. This is a motto full of meaning that should guide us in all walks of life, whether we are higher up, like presidents of Constitutional Court in Germany and the vice president that we will be hearing, or the Supreme Court, the Supreme Court of Human Rights of the Europe, distinguished from the European Court of Justice. That means the Strasbourg Court vis-à-vis the Luxembourg Court. So we are clear about the importance of both institutions. And thank you very much for your presentation. It is my pleasure now to call upon Vice President Doris König. She is the Vice President of the Federal Constitutional Court of Germany. We are happy and pleased to have with us also the President, Harbarth, and also I just recognized the President Levitz, who joined us. He conducted the session where I was, for that reason I was late to come to this one. And now you have a witness that I'm saying the truth. Vice President König will share her insights on German Federal Constitutional Court role in protecting liberal democracy and the rule of law. In addition to her judicial duties, she has played a significant role in international legal forums, including chairperson of the International Foundations of Law of the Sea, and as Germany's member of the Permanent Court of Arbitration at The Hague. Throughout her career, Professor König has contributed substantially to the protection of constitutional democracy and the promotion of international legal standards through both jurisprudence and academic leadership. Please.
Thank you very much. Let me start my presentation by expressing my gratitude to have been invited to this panel. And let me say how happy I am that so many of you have come to listen to us. I think this is really a good sign, and I'm very happy about this. As we are all aware now, over the last 10 to 15 years, the Western concept of liberal or constitutional democracy has come under increasing pressure, not only in Europe, but also in other parts of the world, and I'm very sorry to say, not least in the United States. Liberal democracy has to be safeguarded by the rule of law. Democracy and the rule of law are two sides of the same coin. Democracy as majority rule always runs the risk of curtailing the rights of the minority and restricting the free formation of opinion and political will for the sake of maintaining the power of the majority. In order to prevent this, state authority must be bound by law, and state action must be subject to review by an independent judiciary. This shows that judicial independence is crucial for the protection of liberal democracy and the citizens' fundamental rights. Autocratic regimes erode democratic institutions by bringing them into line, among them the judiciary. In particular, they seek to undermine the independence of the judiciary so that their efforts to restructure the state will not be hindered by judicial review. Justices of Supreme or constitutional courts are especially affected as the broad impact of their decisions, their power to have the final say on the interpretation of the Constitution, and the power to strike down laws give them significant influence on the political system. Measures against the judiciary usually involve the government removing independent judges and filling the vacancies with their own supporters. We have already heard this. In addition, procedural rules are changed in such a way as to impede or significantly slow down the court's work. Critical judges are threatened with disciplinary measures. These measures, and that was also mentioned already, are often implemented under the guise of legitimate aims, such as fighting corruption, strengthening democracy, or getting rid of judges who are part of a detached elite or, worse, enemies of the people. To prevent the transformation of liberal democracy into autocratic rule, the independence of judges has to be guaranteed by constitutional or other apex courts at the national level. And if the national level is, or the national judiciary has become victim to capture and curbing by super or international courts at the regional level. In Europe, as we have already heard, judicial independence is safeguarded by the European Court of Human Rights in Strasbourg and the Court of Justice of the European Union in Luxembourg. That might be a bit confusing, but I think we have worked this out already. Since the crucial role of the Strasbourg Court has already been addressed to by President Bošnjak, I will limit myself to a brief overview of important principles set up by the Luxembourg Court. The court came to the conclusion, and I simplify this very much, that effective legal protection, according to Article 19 of the Treaty on European Union, can only be guaranteed by the courts of the member states if they are independent and impartial. This presupposes that a court, quote, exercises its judicial functions wholly autonomously, and that it is thus protected against external interventions or pressure liable to impair the independent judgment of its members and to influence their decisions, unquote. This also includes the protection against judges' removal from office. Another crucial element of judicial independence is the appointment of judges. This is particularly important in respect of judges of apex courts. In particular, it is of key importance who is responsible for the selection and election of apex court judges. Basically, there exist two models in Europe. One model relies on proposals made by independent commissions or councils, for instance, bodies that do not consist of representatives or only of very few representatives of the legislative or executive branches. The other model involves elections by the legislator with qualified majorities, and that is the model which is followed in Germany. In Germany, the Federal Constitutional Court is divided into two senates consisting of 8 justices each. Half of the justices are elected by Parliament, Bundestag, the other half by the legislative body representing the federal states, Bundesrat. The justices are elected with a 2/3 majority alternately by one of these houses. On the whole, and I cannot elaborate on this due to time restrictions, the political parties in Germany have considerable influence on the selection and election of FCC justices because they are the ones who propose the candidates. Why is the court nevertheless widely respected for its independence and impartiality then? One of the most important reasons is that a 2/3 majority forces the political parties to propose persons who are also acceptable to the opposition parties. Since the proposing party has to find support from the opposition, the candidates usually are highly qualified lawyers who are integrative, non-provocative personalities. The requirement of a 2/3 majority also ensures judicial independence because the court cannot primarily consist of justices who are closely associated with the ruling party. Due to the demolition of the constitutional courts in some other countries, and I want to mention Poland and Hungary, and also due to the increasing electoral support for the German right-wing populist party, a debate was initiated about a year ago on how to protect the Federal Constitutional Court against such measures and make it more resilient in times of political turmoil. In December last year, the German constitution was amended accordingly. The basic structures of the court, 2 senates with 8 justices each, a term of office of 12 years without no possibility of re-election, a retirement age of 68 years, and the right to establish its own rules of procedure are now protected in the Constitution itself and could only be changed by a 2/3 majority vote in both houses. It was decided, however, not to lay down the requirement of a 2/3 majority for the election of the judges in the basic law. That was a hotly debated issue. The main reason for this decision is that that requirement is too susceptible to political gridlock. These amendments are important to foster the FCC's resilience against anti-democratic attacks on its independence, which might be coming in the future. Nevertheless, we should always keep in mind what Germany's first democratically elected president, Friedrich Ebert, said: "Democracy needs Democrats. Without a majority of the population supporting and defending liberal democracy, even the best legal rules cannot prevent autocratic regimes." So it's on us to fight for that. Thank you very much.
Thank you very much, Ms. Vice President, for the excellent presentation, and also for the last sentence, which is a call for action, and a call for active citizenship, and a call sometimes to go to the streets. This is what we have to do in Israel now.
That's true.
Now I wish to invite our colleague, Professor Elise Muir, the head of the Department for International and European Law at the Catholic University of Leuven in Belgium, to speak on the ELI Charter of Fundamental Constitutional Principles of European Democracy, which we mentioned a number of times here. She was a co-reporter, as was mentioned already, and she is Vice Dean for Research and head of the Institute of European Law at Leuven University, as well as visiting professor at the College of Europe in Brooks. And she is engaged in research, and what I would like to emphasize that Professor Muir has led major research initiatives on non-economic EU law, non-discrimination, and the collective enforcement of European values, with an extensive publication record and editorial roles in top European law journals. She plays a central role in shaping contemporary European law legal thought, particularly in the context of democratic resilience, rights protection, and the evolving authority of the EU institution. You have the floor.
Thank you very much, Mr. Chairman, and I would also like to thank the organizers very warmly for this very kind invitation. It's a great honor to be part of this panel and also to address such a prominent audience. We've heard from the previous speakers a lot, many thoughtful analysis on how to challenge threats to judicial independence. I thought that I would use the time allocated to me to indeed present another aspect or other aspects of the debate on threats to liberal democracies, which we indeed have been dealing with in the context of the report that led to the drafting of a charter, which I brought a copy of. Sometimes it's good to see paper documents. The Charter of Fundamental Constitutional Principles of a European Democracy. In essence, this charter is intended to answer a question. How can we strengthen the visibility of the constitutional principles on which European liberal democracies are based, and how can we make these principles more operational? These questions are the questions that the European Law Institute asked us, a group of experts, to reflect upon a few years ago. And perhaps I may take a second to explain what the European Law Institute is under the scrutiny of its president. For those who are not familiar with that organization, it is an organization based in Europe which brings together prominent experts from academia and as well as practice in order to provide independent advice and informed advice to European decision makers, if that is a correct summary of the purpose of the organization. And so that organization asked myself and a group of colleagues to work on a text that would reassert the fundamental principles of a constitutional liberal democracy in Europe. And that's what we've done, and this text, the drafting process, has led to indeed a charter. So we've wanted to signal with this title its form of high normative authority. Now the charter fills in an important gap, because until it was adopted by the ELI, the European Law Institute, there was no text in Europe seeking to bring together or to identify and bring together the key fundamental constitutional principles of European liberal democracies. There exists very important legally binding text on European fundamental rights, and we've heard several times the president of the ECHR. There also exists a Charter on Fundamental Rights, a Council of Europe checklist on the rule of law, more recently a Council of Europe Convention on Artificial Intelligence, the rule of law, democracy and human rights. But there existed no large-scale exercise to identify common constitutional principles of a European liberal democracy. So what this charter now does is to try to bring together the existing materials. Of course, the idea is not to compete between valuable or create competition between valuable sources. It is rather to consolidate, to complement the existing documents. So, for example, what we try to do is to define what we understand as a liberal democracy, to reflect on the idea of constitutional integrity, constitutional entrenchment, protection of certain core aspects of a constitution above others, and to modernize the reflection on constitutional principles, as I will try to illustrate further in a second. The core underlying principle on which the Charter is based is the idea that was already spelled out by Professor Pichonnaz earlier on, that European liberal democracies rely on the rule by the majority, constrained by the rule of law, and with all due respect for fundamental rights, in particular those of the minority. Now, I want to say a word about the process that has allowed us to bring this charter together, because it is related to the form of legitimacy that the text has. The process by which we have come to this charter has been placed in the hands of a group of academics and practitioners with a large-scale consultation process. So we produced a first draft, and this draft has been disseminated, presented, open to feedback, with the very generous support of the network of the members of the European Law Institute in Europe, and I would say across the world, because the text has been circulated to many bar associations, high courts across the globe, and we have been trying to respond to the various comments we have received. The sources on which we rely to identify the substance of the principles set out in this text are a combination of constitutional text, case law interpreting this constitutional text, legislation, because increasingly legislative instruments are used to give a concrete expression to certain features of our liberal democracies. In the earlier panel, in which you will remember, Advocate General Julian Cocotte mentioned EU legislation to protect certain aspects of the freedom and the quality of plurality of the media and information. as well as, of course, academic work, again, from Europe primarily, but also drawing on literature from the United States, South America, or South Africa, South America as well. So it's a text that has its center of gravity in Europe, but that is possibly meant to resonate beyond the frontiers of Europe. Very concretely, the text is composed of 36 principles gathered in 7 categories, and each principle, in the tradition of the work of the European Law Institute, comes with a 1 to 3 pages long commentary. This commentary is important because it explains to the reader how we arrive to a compromise on the formulation of the principle. So it sheds light, interpretative light, on the principle. And we hope that that text can progressively become a text of reference for practitioners, decision makers in Europe and possibly beyond. I thought what I could do to illustrate the kind of content of the text is to pick up a few principles. I'm not going to discuss the 36 ones. Professor Pichonnaz has already expanded, I think, in a good degree of detail on principle 32, on automated decision-making. So I was intending to discuss it, but I will leave it aside because I think we heard quite a lot already. Instead, I would like to perhaps draw your attention to principle 6, which is entitled Protection Against Disinformation. By picking up these 2 principles on artificial intelligence or on disinformation, I intend to show you that the Charter does more than just dealing with the traditional issues of rule of law, judicial independence, fundamental rights protection. It seeks to modernize the debate on constitutional foundations of our European liberal democracies. And for example, Principle 6 on the protection against disinformation has a first paragraph that states that public authorities must provide an effective legal framework against disinformation. Paragraph 2, all entities that provide access to public space, such as media undertakings, social networks, online platforms, have a special responsibility to counter disinformation, whilst respecting fundamental rights, including freedom of expression. And in the commentary that follows, what we do is to define what we mean by disinformation, insisting on the deceptive intent of those who disseminate poor quality information, of badly intended quality information. We call on public authorities to protect the public space for a healthy democracy to be able to operate, illustrating the possibility of relying, for example, on legislation or non-regulatory binding instruments to protect the functioning of social media. And we acknowledge that any limits on the freedom of expression that may be warranted to protect the quality of public debate and to protect against disinformation must be justified and proportionate. So we acknowledge that there is a balancing exercise that must be performed within an organized constitutional framework. And a second principle, or a third principle I wanted to draw your attention to illustrate the substance of the Charter is Principle 23. Principle 23 states as follows: private parties whose activities substantially impact on core elements of a liberal democracy may be subject to constraints based on those that apply to the exercise of public authority. Our intention here is to draw attention to the fact that a reflection on the constitutional principles on which our European liberal democracies are based cannot be done by limiting our analysis to public players. We have to also look at non-state actors that indeed have the power, as is very clear in terms of media and plurality of media. These private actors have the power, unfortunately, to distort the quality of public debates. So we wanted to assert that these private parties also have duties to comply with the basic principles on which our European democracies are based. I hope to have given you a sufficient food for thought and interest for the Charter, and that you will go and have a look at it very soon. Thank you very much for your attention.
Thank you very much, and to be, giving credit, full credit, Professor Muir did this very important charter with Professor Tridimas, who was at the University of London, now he's in Luxembourg. So it is a fine work. It is a fine work, and that shows that academic scholars are not only writing to 10 of their colleagues around the world, but they write to the public, to the decision makers, and they aim at influencing the discourse, the public discourse, which is so important, as Doris, you just said about the involvement of the public in such reports, generate this type of discourse. We have a short time for questions, and I invite the audience to put questions. Please.
Professor Demir from Berlin, President of Human Rights Defenders Association. Now, there has been a mention about Poland and Hungary, which are both members of European Union. But there are other countries like Turkey, and which is very important, and it is important to Europe as well. There has been discharge of judiciary, 30% of the judges and prosecutors there, and there are cases before the court. And also, I was in Geneva last summer. UN special reporter had a report that. But the thing is, the courts make judgments, but how can we make the countries implement them? That's another issue. I think I want to hear the opinion of especially presidents and UN special reporters' opinion on that. Thank you.
More comments? Yes, please.
And after the change you mentioned, it was even uneasy for us researchers to conduct the research in the field of constitutional law. I was handling with issues of the relations between constitutional court and ordinary courts, so enforcement of constitutional court judgments in Poland, which is now the history or future maybe. So I started the research in the field of AI and law, and I would like to comment a bit on these issues you mentioned, because I was conducting at 9 a panel about AI and law in the legal practice. So we all speak about AI in terms of risks. Everyone starts speaking about risks. Why don't we touch this field with enthusiasm? Because it's, I was taught about Dworkin's balancing values, and I said this in the panel before. When I'm asked if I want to be decided, to have my case decided by a human judge or AI, I will for sure answer a human judge. But if I'm asked if I want a decision given by a human judge after 3 years, or a decision given within 2 weeks by AI, and then supervised, for instance, in 10% cases by a human judge, and the whole procedure is ended within 1 year or half a year, then the answer is, for me, it's quite simple. So this is the question. Why don't we approach AI with enthusiasm?
Your statement raises the very acute issue of values, efficiency versus justice. So you say I better have a speedy justice which is not exactly right at the advantage of getting it fast. So I'm not sure this will be shared, certainly not by the classic view that we have to put justice over any other values like efficiency, access to justice, whatever, public trust, all the judicial, even the judicial independence had to give way to justice. But your statement certainly is a valid one. Yes?
Okay, here is the microphone. I thought they had. Thank you. I can discuss a lot about this topic because I'm a judge and I'm coming from Serbia. And my country is currently an example, actually, how the doubt in independence of the judiciary can get a political epilogue with a lot of protest and demonstration. But I will not discuss about that. I only wanted to say, as a judge, I didn't say I am a judge in the Court of Appeal and the network judge in the International Hague Network of Judges. And for me, as a judge, the independence of judiciary and my profession means that I have to raise my voice when I think that there are so obvious breaches of and violations of the fundamental rights. And I hope that you understand my message. Thank you.
Gentlemen and ladies, all good things come to an end. And I would like to thank all the speakers who gave us very insightful presentations from their own views and perspective. And I would like to thank you, the audience, who joined and listened to our presentation. No, because there is a schedule, and we have to obey the schedule. I apologize. So thank you all very much, and we look forward to the other sessions. Thank you.